Hi, you're listening to the Lawyer Society Legal Podcast for lawyers, practicing advocates, law students, and judicial exam aspirants.
In this episode, we'll be talking about the factors to be considered when you file a second bail application. Now, what happens when you file a bail application under Section 437 of the CRPC before a magistrate or under Section 439 before the Sessions or High Court, and it gets dismissed on one ground or the other, and you don't go for an appeal? When you don't go for an appeal, or you do go for an appeal and it gets dismissed again, the second bail petition can be filed only when there is a substantial change in the facts and circumstances of the case in hand. Now, what will be a substantial change? That is the major question to be considered in all these matters. You can't keep filing repeated bail petitions before the same court, or you cannot file a subsequent bail petition even before a higher court if that is not in the form of an appeal. One can imagine that an accused is filing a bail petition, say on day 5 after the FIR has been registered and the person has been arrested, and the matter gets dismissed in another 5 or 10 days. But before he has the opportunity of availing statutory bail, which is mandatory bail, he might be able to prefer a second bail petition, but that should be on a strong ground and should be varied from the options, from the grounds which were available to him when he filed the earlier bail petition. So this has to be seen with respect to each particular case and the nuances involved. In one of the earlier cases from the Supreme Court reported in 1989 to Supplementary SEC 605, it was said that the change must not be merely cosmetic and it should be a substantial one. The very same has been followed till date. I will leave the citation below in the description box. Now, what are the different factors to be kept in mind when you file such a second bail petition whenever you feel that there has been a substantial change in the facts and circumstances of the case? The very first consideration that has to be kept in mind is whether you are preferring the subsequent bail petition before the same court or the higher court or a court subordinate to the court before which you file the first bail application. For example, you might have filed the first bail application before the High Court and it was dismissed. You are filing the subsequent bail application before the Sessions Court, which is also possible. Now, when you file the subsequent bail application before the Sessions Court, we must remember that the High Court's decision is binding on the Sessions Court. So they will have to consider the earlier bail petition which was dismissed by the High Court and on what grounds was it dismissed, so on and so forth. Everything has to be considered by the Sessions Court when it hears the subsequent bail petition you are filing. It is always better to go with clean hands. You have to mention the details of the earlier bail petition, the reason why it was not granted, and why you think there has been a substantial change. All this has to be mentioned in the petition itself. Now, what if you are filing the subsequent bail petition before the same court? There have been numerous decisions from across the courts and also the Supreme Court that when you file a subsequent bail petition before the same court, it is the same judge who has to hear the matter. If he is available, then the registry has to place the matter before the same judge. Now, you have to understand that only when you disclose the fact that you had earlier preferred a bail application before the same court will the registry be able to place the matter before the same judge. So it is like one depends on the other, and when the same judge hears the matter, he is best suited to hear your case. When the same judge hears the matter, he is also able to judge whether there has been a substantial change in facts as you claim. And suppose you don't disclose and the registry has placed the matter before any judge and such judge has granted bail, the same may be a ground to set aside such bail because the same judge did not hear the matter and you didn't come with clean hands and you didn't disclose the fact that you had earlier filed a bail petition before the same court. So it is better for the accused side counsel to disclose the fact and ensure that the matter is placed before the same court, because all this can come against the accused even if bail is being granted. One must remember that the principles I have discussed thus far are also applicable to anticipatory bail applications, because in the case of Jagmohan, Bahl vs State NCT of Delhi, which was reported in 2014, 16 SEC 501, and in the case of Gati Limited vs T Natarajan Piramiajee, reported in CDJ 2019 SC 662, it was again held that all these principles are also applicable to anticipatory bail applications made under section 438 of the CRPC. So it is seen that any bail, be it AB or regular bail matters, they have to be placed before the same judge. And if you are placing the matter before a court which was not the court which heard the earlier bail application, you must disclose to such court that you had preferred the earlier bail application before the High Court or the Sessions Court, as the case may be, and you have to ensure that the judge is aware of when you filed it, how and on what grounds it was dismissed. Now, coming to the question of how you can establish the change in circumstances. The first and the most obvious change in circumstance is when a charge sheet has been filed. So when an FIR is being registered and an arrest is being made around that time, you are filing a bail petition, it is getting dismissed. Subsequently, you've been waiting for a time when you can file a bail petition. It is not yet the time for a statutory bail. So in between the time when the arrest is being made and the time when you can avail statutory bail, the charge sheet is being filed. So in such a case, the charge sheet being filed means the court will have more material to consider, and that means that you can quote the same as a ground to justify that there has been a change in circumstance. Now, there are two cases from Gujarat High Court which discuss this principle. One is JS Bhatt versus State of Gujarat, reported in 1992 to GLR 832. The other is State of Gujarat versus Navinbhai Patel, reported in 2004, 1 GLH 754. I have left the citations in the description box. Please do go through them. In both these cases, it was said that filing of charge sheet is a change in circumstance, is a substantial change in circumstance. Now, the next one is when the witnesses are turning hostile. They don't substantiate the prosecution case. This was observed by the Rajasthan High Court in the case of Panchu versus State. The case number is Crl MB Case No. 3452 of 2017. Judgment dated 30 May 2017. The next one is when a mandatory procedure has not been followed and the same has been admitted by the concerned officer, the investigating officer, in his witness statements. This was observed by the Rajasthan High Court again in the case of Sonaram Bishnoi versus Union of India. Case number Crl MB 4390 of 2018. Judgment dated 10 July 2018. Likewise, you can imagine various scenarios which you can creatively call as substantial change in circumstances. It depends really from case to case whether you can say a particular change is so substantial that the court can entertain the subsequent bail petition. Now, it is very essential to remember that if you file it at the wrong time and the court remarks that you are wasting the court's time, it creates a bad impression on the accused side and certainly on the counsel himself. This might hamper the possibility of filing a subsequent bail application when there is any valid substantial change. So it is always better, I think, to go for the right time and look for the right time to file the second bail application, just like how you will have to wait for the right time to file a second quash petition. I hope you found this episode useful. In case you want to read a detailed article on the same topic, you can purchase the March issue of the Lawyers Society Digital Law Magazine. I will leave the details of the same in the description box below. You can also subscribe to the Digital Law Magazine. I will leave the subscription plans and details down in the description box. Please do like and share it with your friends. Do share it with your legal community and your WhatsApp groups. Do subscribe to our YouTube channel. Do follow us on Spotify. Thank you.